Father, we just want to thank you so much, Lord, for giving Karen the gift of teaching so that she can share her wisdom, knowledge, and experience with us regarding financial and estate planning. We thank you for blessing us, Lord, so much with financial resources. May you guide us and fill us with the knowledge of your will so that we may be a good steward of your gift, pleasing you in every good way when we use this gift, Lord. And I pray that, Lord, that you bless the time that we had together and that you would teach us, Lord, what we need to learn today so that we can be a blessing to our family and others. We pray all this in Jesus' name. Amen.
Thank you, Amara. And I'm just so thankful that all of you are able to attend for this next session on the basics of estate planning. And I just wanted to encourage you, if you do have any kind of questions for any of the sessions, you're most welcome to call me. My cell is 713-264-2475. That's 713-264-2475. Or you can certainly email me at my work email at hok@gwnsecurities.com. And I would welcome any question. I always think it's wonderful if people can learn how to make good decisions for themselves and their families. Let's go on to the basics of estate planning, trust, wills, and probate. And please ask questions either online or in person, and I would welcome those. At the end of the section. Okay. Why bother? A lot of people, including many attorneys, do not have their own wills for their families, and usually they will get one done when they're going on a big trip. That's when I'll see a lot of them have a lot of activity, and they'll get their own wills done for themselves and their families. But why bother? It's because it really is to protect you, your estate or your things, and your loved ones, really to simplify life for your loved ones. Now, I'll be very honest, getting these things done and prepared ahead of time, it's kind of a humbug for yourself. The idea is that you want to minimize the amount of frustration, confusion, and just panic of your loved ones that you have left behind. So really the simplification is for your loved ones and really not for yourself, because there's going to be some steps you'll go through in order to get your wills or trusts and your documents in order, but it will be well worth it. Now, here's the importance of having a will or a trust. You really want to distribute your property as you want it done. You want to name either an executor or an executrix if it's a female, or you want to, if you have a will. For a trust, you're going to have a trustee named. It's usually yourself first until you either pass or become incapacitated. Then your successor trustees then will become the trustee of your trust and execute the plan that you wanted done in its place. It also reduces a lot of costs and a lot of time for your family and your loved ones, whether you're alive and incapacitated or whether you have passed away. This makes it very much simpler and easier and more convenient for your loved one to carry out the things that you want done, whether you're incapacitated or you have passed away. If you need, you can create trusts to protect the assets that are left to beneficiaries or your heirs. Trusts take effect while you're still alive. So you are usually you're the first trustee on it, and you just carry on life as usual. But if you become incapacitated, then your successor trustee or trustees take over and go into your shoes and carry out the wishes that you would have wanted, whether you're incapacitated temporarily, permanently, or you have passed away. So as, for example, in my mother's case, she was of sound mind back in the 80s. She had a trust done. And so she just carried out, did her usual taxes, did everything the same old way. But when she became incapacitated with severe Alzheimer's for 17 years, I had been named as the successor trustee. So while mom was still alive, but very incapacitated, not knowing who you were, who I was, or what was going on around her, I took over and basically became Rose Ho. So I could buy and sell her assets. I could make payments out of her trust on her behalf. I could do everything on her behalf. So I basically acted like Rose Ho. And then when she passed, since I was still the trustee on that trust, I was able to have her house replumbed, rewired, fixed up, cleaned up, and I could sell everything. And there was no probate. It was a much simpler process. And I did it from Houston. She was in Hawaii, and I never had to fly home to get any of these things done. I could do everything by phone. I could close out her brokerage account. I could close out her bank accounts, everything from Houston. I did not have to fly home to Hawaii. So that really made it easy. And my 4 brothers and sisters, they were all in agreement. So anything I did, they were in agreement with. Number 5, you really want to avoid fights among the family. It's amazing whether you have an extended family or a nuclear family or a blended family. It is amazing when money and assets are involved, how much comes out of the woodwork, and people fight over the silliest things. In my sister's case, she had a brother-in-law that wanted her laundry basket. Go figure. And it was left a very bad feeling in my sister's mind that her brother-in-law was trying to take off with her little laundry basket. I don't know why, but really, when you lay things out in your will or your trust, it really avoids people taking advantage during a time of confusion and sorrow and grief. And so you have already laid out what you want done and how you want it done and how you want to be honored during this whole process, and keep your family and your loved ones and friends intact. So it was it had nothing to do with, money or anything, but it really kept the family relations very strong and loving. Okay, if you don't have a will or a trust, most people don't realize that for the state that you live in writes your will for you. And it's going to go to pass by blood and family lines, blood and marriage lines, whether you like the people or not. So Texas is going to decide who your beneficiaries are, who the agents will be of your assets, who the guardians might be for your minor children or dependent adults. And they may be naming people that you find inappropriate to take care of both the persons or the assets. So you really want to avoid that and take the time and effort to get either wills or trusts in place. Also, when you have to have guardianship issues, and when you have to go through what we call intestate probate, where probate is done because you don't have a will that you had drafted up with your attorney, it's going to increase the amount of time and costs for you to actually distribute out your assets and you carry out your wishes. Your wishes may not be carried out at all, and because the state has now decided who gets what. For those of you who have minor children under 18, or you may be a grandparent or an adult caring for a minor relative or a friend's child because something unfortunate had happened to their biological parents, they maybe had passed or they're no longer in the picture, and you have either taken them in as your own children or you're now their guardian or whatnot. You have to be very careful. If the parents had not made provisions or the grandparents had not made provisions in event of their incapacitation or their passing away, the surviving spouse or whoever is not automatically the guardian of your own children. If that is the case, you have to go to court. The surviving spouse has to go back to the court every year and declare what they purchased, how much they spent for their child every year. So it would be very good if you have minor children under age 18 or grandchildren that you are the legal quote unquote parent of, to have your wills or trusts name. First of all, your surviving spouse would be the guardian. Okay. And if you both pass away, then who might be a backup a guardian for your children and or their assets to care for them as they grow up. There is also, if you don't have a will or a trust, if you have elderly people or children or adults with special needs, and I'll give you an example. My nephew has a severe bipolar. And so I am hoping that their parents have put into place, in case of their passing or incapacity, that they have made provisions that he will be cared for the rest of his life. I do have clients that have special needs children. These are like adult children. They're 19 or above. And so there was one couple that it was up in North Texas, and they had made special needs trusts so that it could be taken care of if either one or both of the parents passed, or if one of the parents passed, they had put provisions and assets in place so that the child could be cared for his or her lifetime. The other client I had was a divorced single mom who retired early at the age of 60 because she had a son who was born almost, it's like cerebral palsy, but he was blind, he was deaf, he was mute. He was 19 years old at the time I met them. And her concern was if she passed away, because she was not in the healthiest of health. If she passed away, she had her wills and things done, as well as put some assets in place if she didn't survive, that there would be enough for his life expectancy to take care of him and pay for the cost. So we actually had that costed out, and we had some things put in place for her to use during her lifetime. And also at her passing, there would be sufficient to care for her son, assuming. We also looked at the literature on what the life expectancy of his kind of condition was. So we tried to get something that was reasonable. Okay. Now, if you die without a will or trust, and I'm sorry, it's a little small, but I'm kind of going to go over just to give you an idea. If you die without a will, and whether you're married with and without children, it gets really complicated. So let me walk over to here and kind of point out. If you're married, yes, then it's going to ask, do you have children? Yes or no. If you have children, now remember, we are in a community property state in Texas. If you move to another state, you need to check if you have community property or not, because the rules and laws are different in different states, depending on what kind of, how they designate what type of property you have. If you have children, just because your spouse has passed away, it doesn't automatically mean that the surviving spouse is going to get 100% of everything. That is not the case. If there are children with your current spouse, whatever age they are, the spouse will get 100% of the community property. Community property is where you have acquired things and assets and monies while you are married together. So let's say we have a young couple, they got married, but before they were married, one of them inherited a whole bunch of assets and monies from mommy and daddy or whoever, okay? The inheritance or the gift that is kept separate from the community property and is never mingled into their community property assets is called separate property. That should be kept separately unless the couple has decided to mingle it together, then it becomes community property. So given that, if you have married, your spouse dies, and you're in a community property state like Texas, the spouse gets 100% of the community property. But if they have separate property, say by gift or inheritance, that is clearly delineated, and it shows that one of the deceased person got it from gift from parents or relatives and kept it separate, that is called separate property. So what happens is the surviving spouse only gets 1/3 of that separate property, and the children, whether they're good or naughty, they get 2/3 of that separate property, and the surviving parent doesn't have control of that. If it's real estate, if it's separate property, and I know among Asians, we have a tendency to purchase real estate for the children, even when they're very young. They'll buy houses or land or whatever. But if it's separate property that perhaps the deceased spouse had inherited or been gifted from his side or her side of the family, that's separate property. Then the spouse only gets 1/3, okay? And the rest goes to the children after the spouse is, no, the children get 2/3 of the separate property, and then the spouse gets the 1/3, and then the 1/3 of the share goes to the children after the death of the second spouse. You can see how complicated this is when you don't have a will or a trust. Now, if you don't have children, the surviving spouse gets 100% of the community property and 100% of the non-real estate separate property. So I guess that's the pots and pans and dishes and all that kind of stuff. But they only get 1/2 of the real estate separate property. And the parents and other heirs are going to get the other half of the real estate separate property. Now, I know this is going to be very confusing. That's why I say I am not an attorney. You definitely want to see a competent attorney, a reputable attorney, to have your wills and or trust and ancillary documents created. Okay, now I'm going to kind of skip this because it's very involved, but I just wanted to illustrate how complicated it can make it for your family loved ones if you do not have these things in place before you pass or become incapacitated. If you aren't married, it still can be complicating. If you have children, yes, then if you aren't married, whether divorced or you just had children outside of marriage, those children can surface and they will get 100% of all property. If the children have passed away, then their split goes to their children equally. Now, if you don't have children and you don't have a will, the parents are going to get equal shares of the assets. If there are no parents, then it starts going to brothers and sisters, grandparents, and other heirs according to the law. Now, I'm going to go back a little bit to this one, because we see this happening quite a bit all over the world and a lot in America. If you are married and you have children and you pass, but that child is from a non-marriage relationship, then the surviving spouse gets half of the community property, 1/3 of the separate property. The children from another relationship, this is not a child of the surviving spouse. The children from another relationship are going to get half of the community property and 2/3 of the separate property. And real estate, if it's separate property, then the spouse's 1/3 separate property goes to the children after the second spouse's death. And this actually happened with one of my clients. It was unfortunate where the husband actually committed suicide. And he had a daughter many years ago, but he gave up all rights to her very early on. And the husband and wife had purchased a lovely home up north in the Woodlands. When he passed, after he had committed suicide, even though he had given all rights to the other non-marriage daughter, she surfaced. And the surviving wife was not able to sell that house because the child from that other relationship owned the other half of the house. There was no way she was going to allow the surviving wife to sell it. So they've been in a struggle for many, many years. And some of the other separate property that the husband had. So, I just keep in touch with them and kind of see where she is with it periodically. Last I spoke with her, it's still quite a nightmare for her. So she really can't move on with her life. This is one of the reasons, if you have children or don't have children, or you're from a relationship that is in a non-marriage relationship, you really want to lay these things out in your wills and or trusts and other documents so that don't create a lot of grief for your surviving loved ones. Okay. I think it's frozen. Yeah, good. Yeah, I think if I don't press it fast enough, it kind of freezes. All right, there we go. Thank you. So the basics. The estate, most people will say, well, my situation is very modest. I don't have very much. Well, everyone, I don't care who you are, how modest your situation or how much you might have, everyone has an estate. It's everything you own. So, for example, it could be your bank accounts, your credit union accounts, your investment accounts, your retirement accounts, your life insurance policies, your homes or your real estate land that you may have, your car or cars, your pots, your pans, your jewelry, your clothes, furniture, art, everything you own, including pets, is included in your estate. So if you think about it and you examine your own situation, you now realize you have a pretty nice estate. Now, this part is how property passes. And we'll kind of go through that to give you a good understanding. It's going to pass by law. It's going to pass by contract. It's going to pass by a trust, or it's going to pass by probate, with or without a will. And I'll go a little bit more in detail. As we saw this a little earlier slide, when you die without a will, this is how it's going to pass. So you can, if you want, you can email me and I can email you that one slide so you can look at it more closely, but it's a little confusing, even for the very best of us. Now, I'm going to add in one thing. I have enough clients that are married for a US citizen married to a non-US citizen, whether they're Canadian or from Hong Kong or from mainland China. So you married a non-US citizen, you really need to see an attorney that is versed in both US as well as the foreign country estate planning laws, because they may be very different and you want to make sure it's done right. So you would have to have an attorney on both sides of the ocean to make sure you're doing what you want for your loved ones. Okay, so your estate, as I said, it's going to pass by your will. So your will is basically you make the rules, you make the instructions. And the good thing about it is, even though people are very hesitant to make the will because they don't know who to name as their executor or executrix in the case of a female, who's going to take care of the children or who's going to take care of dispensing of all the property and assets. Well, please understand that you can change your will anytime you want, as long as you're of sound mind and you have capacity to do it. You can change the rules, but get one in place. And when I speak to couples, this is what hangs up the majority of them from doing it. They can't figure out who to name as the executor, or if they're young minor children. I'll often hear, there's no way I want your brother, blah, 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 to take care of our kids because they would be horrifying. Or I don't want a sister-in-law so-and-so. There's no way I'm going to let her get her hands on our stuff. It's amazing what I've seen over the many years. But get a will in place, because you can change your will really as many times as you want. As you get to understand who the people that you've named in the wills, you can always change them out if you find someone that's more appropriate or more receptive of it and are willing to do that. You also want to check, when you name an executor or trustee, that they know about it and that they are agreeing to it, because they don't want, if in case you both pass away, they don't want your children showing up at their front door with their suitcases and saying, oh, by the way, you're going to take care of us. So you want to let them know, and so they're going to be prepared. Now, I think I shared this in earlier sessions with my older sister and brother-in-law. They had 5 children, and there's 5 of us siblings. So if they are both knocked out for whatever reason, that would leave 4 of us, but 5 children. So each one of us 4 brother and sisters and my mother were given 1 child. I was given the eldest son. So I took it very seriously. So in my first will, and I probably was in my late 20s, I had a will done, and it said, if I die, everything went to my nephew. And I showed it to my sister to make sure she was okay with that. She was very unhappy. And I said, well, you gave me him, so I'm going to take care of him. And she said, no, but I have 4 other children. I said, well, you better make sure your mother and your other brother and sister take care of their children. But she was still very unhappy. So I went and changed my will soon afterwards, where I left everything, her share. But then if she passed, then they would be put into trust, that my assets would be put into trust to go to her children. And it would bypass the spouse, because he didn't need my money. So I made sure that it was going to go to the 4 children, or to the 5 children actually. And I trusted my brother-in-law that he would not do bad things with my assets, and he would do everything on behalf of his children. So that's the will. Now, a contract is your life insurance, your 401k plan, your 403b plan, your 457, your annuity, your any retirement plan, IRAs, whatever. Those are where it has a beneficiary designation. Now, people will think, well, I have a whole bunch of IRAs, things where it says beneficiary designation, but you know what, I'll just write in my will, leave everything to so-and-so. Well, most people don't realize it, that a contract, in this case, the life insurance, the 401k, the IRAs, annuity, the 403b, the 457, the retirement plans, they will trump a will every single time. They are more powerful than your will. So if you've named in your will, I want to leave everything to my wife, but your life insurance, your 401k, your IRA, your 403b, your annuity, your retirement plan says, I leave my 401k or I leave my life insurance proceeds to my sister. Well, your sister's going to get it. Now, Texas has updated some of the laws so that it doesn't bypass the spouse. So there is some provision for that, but still, that's in Texas. I don't know about the other states. So you probably want to double check anything that you had a contract that had a beneficiary designation, that you want to update them and just check them periodically that it's going to the correct persons that you truly want to have your assets. Trusts are, there's living trusts that are revocable. That means you can change it anytime. And then you have irrevocable trusts. Those are usually done for estate tax planning purposes when you have a huge multi-million-dollar estate and you want to avoid the estate tax or minimize it rather. So those are irrevocable life insurance trusts typically. But a living revocable trust, it really acts like a will. It's active while you're alive, and you typically are the trustee of it while you're in full capacity. And then when you become incapacitated, or if you pass away, then your successor trustee takes over into your shoes and then carries out the terms of your trust, how to distribute out your assets, pay your bills and all that kind of stuff until you close out your trust. So the will goes through probate. So you have, and I'll talk a little bit about that in a couple more slides. The will, you have to go through probate, and that will take a little bit more time and money. When you have a trust, as my mom did, and I have one now, you don't have to do any probate. That's only assuming you have fully funded your trust and retitled your accounts, your bank accounts, your whatever your property deed, your car. So in my case, when I got my living revocable trust done in 1993, I had my condo named the Karen Ho Living Trust. I had my car named the Karen Ho Living Trust. I had my credit union accounts in the Karen Ho Living Trust. My brokerage account was in the Karen Ho Living Trust. Yeah, so all of those things are in the living trust. So then my trustee could then distribute and dispose of my assets without going through any probate. And again, I can change my plan or my rules of my trust anytime I want, just see my attorney, pay a few more dollars and get things updated, or update the language of the laws, estate tax laws, because they do change periodically. Even if you haven't changed anything that you wanted done, you can want to make sure that your trust language is up to date. So about every 3 to 5 years, you might want to check with your attorney and just make sure, hey, is there anything new that I need to incorporate into my trust or to my will or whatever? And then just have him or her update them. Oops, I forgot one. Now, and your estate can also pass by law, and you'll see some of this. Joint tenant with right of survivorship. I'll see this on a lot of bank accounts. So if one person dies and the rest of it just goes to the other person. Intestacy, that means dying without a will, and we've gone over that a couple times already. Pay on death and transfer on death. I'll see this in investment accounts or bank accounts. So when one person passes away, and if they have a TOD or a POD, then the asset just passes to whoever they name on the pay on death or transfer on death in their paperwork. And that's a great way to bypass the probate for that, well, for that part of it. It gets assets to your loved one. Now, the basic documents that you're going to get most likely from a reputable attorney, and they may make suggestions for additional documents for you to have in your situation. You're either going to have a will or a trust. Now, if you have property outside of the state of Texas, the way the probate laws work, you have to probate where your assets are. So if you have some property in Hong Kong, China, Nevada, Massachusetts, California, but you also have property in Texas, you will have, if you have a will, you will have the Texas property probated in the Texas probate courts here. But then your executor or executrix has to fly or go to where your other properties are, your other real estate, and your other stuff, and probate it in those states, which is a humbug thing to do, costly and time-consuming and very exhausting. So that's why you want to have your attorney. Usually, when clients have properties, real estate properties, and significant properties outside of the state of Texas, I will suggest that they see an attorney and put it in such a way that they don't have to do, it's usually going to be some kind of trust. So they have their attorney draft the proper things to probate those other assets outside of Texas, so they don't have to have their loved one go fly over there and probate it in those states or countries. I don't even know how another foreign country will probate their things. Okay, then you would also need a durable power of attorney. Now remember, for a will only takes effect when you die. So if you are incapacitated in vegetative state, or you're just out of it for months or years, your will do nothing for you or your family. So you want to have things that take care of you while you're incapacitated, and you're probably not going to be coming back from it for quite some time, if ever. So but still have your loved ones able to care for you while you're still alive but incapacitated. That's where your durable power of attorney helps your loved one, whoever you name has a power of attorney. That takes care of your business stuff, your assets, your accounts, your investment accounts, the business side of your life, your finance side of your life. You can buy and sell the properties. You can get into their investment accounts. You can do whatever needs to be done. Now, when my mother was alive, she had a brokerage account, which I managed for her. It was a modest little account if we ever needed it to care for her, because she had Alzheimer's, severe Alzheimer's, for 17 years, and she was at home, and it was quite expensive. It was like $12,000 a month out of her pocket to pay for her care if she ever needed 24/7 care. But usually it was myself, my younger sister, that took care of her 24/7. So that really cut down a lot of the cost, and we also made sure she got excellent care. But in the event she needed to use her assets, I had the ability as her trustee to go and buy and sell shares out of her investment account and use the monies and proceeds for her care. When she passed away, contacted the brokerage investment company, and I said, I want you to close the account, send me the check, because I will deposit it into my mother's bank account, since I was also trustee on that account. And then I will use it to pay for everything that needed to be done for my mother's estate, fixing up the house and selling it. And then after everything was done, then I would distribute it out evenly among the 5 children, whatever was left over. Well, the investment company said, no, if she's died, you're going to have to change the account into a deceased account, and you're going to need all this paperwork done, and you can't have money. And I said, well, I beg your pardon, you are very mistaken. I am trustee on this account. I have full control of it. I'm going to have my attorney contact you from Hawaii, which he did. And he basically told the brokerage investment company that Karen, as a trustee, has full control and authority over that account. So you need to do what she said. So they and they were very nice about it, because they rarely dealt with this, I guess. So they apologized, and they quickly cut a check, had it mailed to me. I had it deposited, and then from there I could take care of my mother's final affairs. Okay, so that's a durable power of attorney, where you can produce that to the investment company, real estate company, or whatever, so that you can transact business on behalf of the incapacitated person while they're still alive but incapacitated. Durable power of attorney for healthcare with a broad HIPAA waiver. That's a broad where you waive your privacy rights. That one is also very good to have if you need to get, it's like a medical authority to, I want medical records, please, such an, XYZ hospital or clinic, please produce the medical records for my incapacitated loved one here, because I want to get a second opinion. That used to be much easier to do, but currently, because of the privacy HIPAA laws, and I've had this happen to some of my clients where they say, well, too bad, the HIPAA laws are more powerful than your little waiver of HIPAA, the HIPAA waiver in the power of attorney. So there was a case where the father had stage 4 cancer, was in the process of dying, and the daughter wanted a second opinion and went to get the medical records from this very well-reputed facility. And they took one look at the power of attorney for healthcare with the HIPAA waiver in it, and they refused it. They said, so sorry, we will not do that. You have to bring your father down here to give permission that we can release the records to him. So that was not a good thing. So you want to check with your attorney to make sure you get a strong, durable power of attorney for healthcare, and with a very broad and strong HIPAA waiver. I don't know what the language would be, but we're seeing this happening more and more. Okay, the living will and the physician directive, there's a number of names for this one. You also can hear it's called the Terry Schiavo, when to pull the plug document. It's not a legal document, but it gives the wishes of the person when they become terminal, and their physician has said they're probably not going to make it beyond 12 months. But they have written in their living will or physician directive or medical directive, either like DNR, do not resuscitate, or do everything you can, spend all the money I have, try to pump me back to life, no matter if it's just one day of more life or, many years to come. So it could go from very minimal, just keep me comfortable, give me drug meds or whatever, just rehydrate or withhold fluid and nutrition, to all the way to spend every penny I have and try to keep me alive. So this one is helpful to the family, because many families will be on opposite sides. One side wants to keep the person alive as long as possible, no matter the cost. The other side wants to pull the plug. And we actually saw this with the Terry Schiavo case, where the parents fought for 10 years with the husband, because Terry Schiavo did not have a living will or a medical directive. So they spent 10 years fighting in the courts and spending probably a whole bunch of money. And in the end, she did pass after 10 years. So if she had had a living will or physician directive, it would have saved 10 years of grief, and they would have hopefully honored her wishes. What's a valid will? Okay. the general rules, you have to be 18 years or older. You have to be of sound mind, okay? You have to have absence of undue influence. Someone cannot be looking over your shoulder, telling you what to write down. We actually had a case up in North Texas where the person was handwriting a will, and her accountant was standing over her shoulder, telling her what to write, basically leaving everything to him. And she handwrote the will, and then she died at whatever time. Well, the handwritten will was so confusing. Even the probate court judge nobody could figure out what it was saying. It was a mess. So they could not even carry out in terms of whatever that was. Plus, it was done under undue influence by the accountant. I don't know what came of that, but I would think they probably would have to go through intestate dying without a will. And she was a very colorful woman. I don't know how many times she was married, but she had like 4 to 6 children from different men, and they all ran the family business. And so I don't know how they were going to split up that. If they did it by intestate with children from marriages or from non-marriage relationships, that was going to be a very confusing picture. So I don't know how that one ended up. And it has to have no fraud involved in it. Okay, so if you can get past those 4 things, the person can have a will done. So even, I will have a number of younger, in the 20s or 30s, say, I'm too young, I don't need a will. I said, I would suggest you rethink that. My niece died at age 17 of a birth defect, which we did not realize. Now, fortunately, she wasn't of legal anyway to make a valid will, but had she died at 18 or older, then she would have died intestate and would have to go through Hawaii's laws, probate laws, and Hawaii is a difficult probate state. It's much more complicated than Texas. So I would suggest whether you're 20 something or much older, get your wills or trusts done. Okay, what's probate? Okay. Probate is basically just the orderly transfer of the deceased person's belongings. Probate means to prove. Number one, you have to prove it was him or her that died, because we do have cases where they will knock off some innocent victim, have it as the deceased person, so that then the deceased person can very discreetly surface and get all the get certain stuff to other loved ones and whatnot, like life insurance and all this kind of stuff. There was actually a case, I think it was in UK. The husband and wife had a multi-million-dollar life insurance policy. They had 2 adult sons. And so the husband and wife said, we would like a lot of money, so let's knock me off. And so he went on like a boat trip or something, and then he disappeared at sea or something. It was something where they declared him dead. And so the husband and wife were able to declare death and collect the multi-million-dollar life insurance policy. In the meantime, the 2 adult sons were just grief-stricken that they had lost their father. Well, it turned out after a few years, they got wind that the father was alive and well and kind of having a great time with mom, living up on the life insurance proceeds. So that broke the family up. So the 2 sons at that point severed all relationships with the parents. And so I haven't heard anything since then. So, to prove that it truly was him or her that passed away, and it was not some innocent victim being knocked off and, the body put in its place. And then it's to prove that the stuff or the belongings truly belonged to him or her that had passed away. Then, standing in line, you have to pay off all bills due, all creditors, any debts have to be paid off. And then Uncle Sam, our government, is next in line. So you have to do the final tax return and pay any taxes in your year of death. And then only then, if there's anything left over in your will, then goes to your heirs. And there's a lot of different provisions in it. And this is where you would speak with your attorney. Okay. What if you become incapacitated by illness or injury? What if you get remarried whether you are widowed or divorced? What if you are widowed? What if you adopt a child? What if you have a blended family from two different marriages or relationships where there are children from the different relationships and the different families? So you really should have, if you're incapacitated, as I mentioned a little earlier, you really should have the durable power of attorney, the power of attorney for healthcare with a broad HIPAA waiver. You should have your living will. And 4, you should have any other documents which your attorney is going to recommend for your situation. Let me give an example of invalid, out of date, or poorly drafted wills. People that died without wills tend to be very notable people. Aretha Franklin, Prince, he died with a estate of 200 million, and I don't know if they're still fighting over it. Amy Winehouse, the singer, she died very early from, I think, drug overdose. Bob Marley, the heirs were still fighting 30 plus years after he died to get his stuff. He was like in the music industry. Jimi Hendrix, his heirs were still battling after 30 years for their share. Sonny Bono died without a will. Kent Cobain, Howard Hughes died without a will. That's why people surface every now and then and say, hey, I found his will and it names me as the beneficiary, and they disprove it. Abraham Lincoln did not have a will. Martin Luther King Jr. did not have a will. Pablo Picasso did not have a will. Tupac Shakur did not have a will. James Brown did not have a will. Steve McNair, who was our NFL quarterback for the Tennessee Titans in the Super Bowl, did not have a will. Quite a few people, in fact, a Supreme Court justice did not have a will. So it's very common that many intelligent, well-to-do people do not have wills. So I would encourage you all to get yours done or trust done. Now, a will, if a holographic will, you can handwrite a will in your own handwriting. The entire thing must be handwritten by you. And it doesn't have to be witnessed. It's called a holographic will. That's why people will surface with a Howard Hughes will in handwriting and say, here's his will and I'm it. I'm the beneficiary. No. And it sign it. But usually if you do a holographic will written in your own handwriting, it's a start. But if you've got certain things you want done, not the usual way, it's just better to have an attorney that's competent, just draft it for you so they can get all the language in with the current tax laws and estate planning laws in place, that there's not going to be any disruption and mistakes, which happens when people write their own wills. The fill in the blank wills that you get at the computer store and those kind of places, or you download them, while they are not technically legal in the state of Texas, and they can be thrown out in a probate court because it's a fill in the blank kind of thing, in Texas, that is really not legit. Now, some places may accept it, but it's a good start if you have a fill in the blank, from a computer store form, or from the, download it from the internet, some generic form. But then you take that to your attorney and have him or her make it proper. So you already kind of know who you want to get things done, who gets what and all that. So you've at least taken the pre-planning step and you're kind of on your way to get it done well. Now, what happens after the loss of a spouse or, I think, did I skip over something? Oh, I think I put a slide out of place. Before or after the incapacity or loss of a spouse, you do want to kind of talk about this. Before your spouse passes away, you want to have the conversation with each other and with the children while they are alive and alert. You want to share your wishes and your values with your loved ones. You want to make it easy on your loved ones and have important contacts, assets, key information accessible to them. I think the little booklet that we had passed out several weeks back, that's kind of in one place you have a lot of information, passwords, and key people and contacts or where the things are that they can access if you need it, and or not, well, you'll be gone or incapacitated, but they can, your loved ones knows where to go and what to do. Now, of course, you would only release that information to the ones that you trust with your life. You wouldn't give it to immature or irresponsible people until you have determined that they are ready to handle such matters. And they could be very young and very mature, and they could be very old and very immature. So you need to use your judgment. Then you should have the draft and update any wills or trusts or durable power of attorney for healthcare, and your living wills updated. So as I said, when I changed my will probably 3 times, and then I had my living revocable trust done in 1993, I make sure, since I've never been married, I have no children. So I Xeroxed the entire trust. It was about an inch thick. And I sent a copy to my older sister and a copy to one of my younger sisters, and also have a love letter on who gets all my little ancillary things like my jewelry, things, little stuff. And so every now and then I will update my information, contact information, address, phone number, account number, passwords, even my safe deposit box. I drew the outline of the safe deposit key on the little love letter and said it's number 77. And when you go to the bank, usually show them you want the box that goes with this key. And I had to put on the signature card so that they could actually access my safe deposit box and all that kind of stuff. So, so make it easy on my loved ones to take care of me when I'm either incapacitated or if I passed away. So before the spouse has passed away, that's what you can do. You can kind of take care of a lot of things in advance. But after the spouse passes, the first thing I'll tell and it's usually a widow, trying to think back, I have yet to work with a widower. I've only worked with widows. So first, and usually the widow, the lady involved, it was usually the man that took care of all the finance business stuff in the family. And the wife was clueless, didn't want to know, didn't want to get involved, didn't want to do any of this stuff. But then the husband dies and they're frantic, they're panicking, they don't know what to do. So that's when I get called in. And I will work with the widow and try to figure out, okay, what do you have? What do you need to live on? How is it held? How do you get access to it? What are all the passwords? And that was the humbug thing too, because a lot of times the husband had passwords, but the widow didn't know what the passwords were and didn't know where to get them. In my older sister's case, she's typical in that sense. Her husband takes care of everything. He's an engineer. My sister is very intelligent. She was like assistant vice principal at a school, so she's not dumb. But when it came to the finance part of their lives, she had no interest in all this. And so she tells her husband, well, honey, what happens if you die, honey? She said, well, just call Karen. And I'm going, you better be talking to each other at least once, 6 months or once a year, and just kind of sit down and show where everything is. And, but after the passing of the loved one, take a deep breath. You're going to have a lot of people coming at you and say, have I got a plan for you to invest? I know you come into some money, there's a life insurance, death benefit, or he's got his 401k and, we can do lots of stuff with that, so I'll tell them, wait about a year after a death before you make a major financial decision. Now, when my dad died in 1967 at age 42, left my mom at age 42 with 5 children, a mortgage, no job, not that much in the bank. After she came out of her shock, she kind of thought things through. She was trained as a teacher, but she had never taught school because she's always helping Daddy in his medical practice as a receptionist. So she did that for almost 18 years at least 10 years of marriage. So after she kind of sat down and talked it over with the Lord, prayed a lot, she turned around and she sat us all around the table and she said, all right, children, get ready. We're going to move to Greenland. I was 14 at the time. Like, Hawaii to Greenland. This is going to be really strange. And she was going to teach, since she was trained as a teacher, I guess she was going to teach the military kids or something on the bases or something. And I'm going, all right, if that's what you decided, we were prepared to buy a lot of warm clothing in Hawaii and fly to Greenland. But after a while, she had second thoughts, thank God. And she decided to teach or find a job in Hawaii. She did, and she did that for many years until she was age 65. So from age, let's see, she was widowed at 42, and she retired at 65. For during that period of time, she was in the teaching profession. She taught ESL to foreign people from Hong Kong. She taught a private preschool as a teacher's aide. Then she became like the principal of that preschool. And then she got her master's in special education and then taught, I think, 20 years in the public education system in Hawaii as a special education teacher. And from that, she raised 5 children, no debt, put us all through college on her very modest salary. I think it was not even $30,000 a year before taxes, but she put us all through college, and she even put herself through a master's level, and my sister through a master's level college, all on her one salary and no loans. And we're just, thank God for that, because God provides. So again, when you're first widowed, I will tell the widow, wait about a year before you make a major life change decision or financial decision. Now, if there's something that you are so convinced and you just know in your heart that this is the right thing for you to do before that 1 year is over, then by all means you do it. But in most cases, I'll say, take a time to readjust and kind of see, what life is laying out for you at this point. Okay. So if you are widowed and you want to, this is just short-term steps you want to take are, just locate the important documents and financial records. Set up your files and records to keep track of the information. Seek professional advice to settle the estate and file your tax returns. So in my mom's case, I had been working with a CPA here in Houston, and I would have him do all her state of Hawaii taxes. I didn't want to be bothered with it. So I would just pay him and let him take care of it. And when she passed, and then I finally closed out her estate after 2 years of, selling all her property, selling all her stuff, closing out her accounts and all that. After 2 years, then I had him do her final tax return, and then another when I closed out the estate. He finished it out. And then you probate or follow the terms of the trust, depending on whether the person has your loved one's spouse had either a will or a trust. You follow the terms of the will or the trust. And then have a trusted, this is really helpful, have a trusted friend or an advisor for emotional support, and also for a second opinion, because sometimes you'll see your dear friend who's been widowed acting kind of irrationally, going to do some stuff that's really not in their best interest. So if you would be the one to kind of knock them on the head and say, hey, wait a minute, you might want to rethink this, because from where I'm standing, this is not looking like a very good thing for you to do. So you might want to have a trusted friend or advisor to give you emotional support and also give you like a sounding board. And of course, you want to notify the key people and loved ones as desired that so-and-so, has passed away. But there are some that have already severed ties with relatives or friends for whatever reason. And they say they don't want, there's no way they want this other person to know that a person has passed away. That's their choice. Okay, so your choices, and you've seen this before, you can do nothing. Then the state of Texas is going to write your will, or you can have a will or a trust done with the appropriate other documents as needed. Yeah, and you've seen this before. Make it a priority. Get organized, seek help, listen, read, learn, review, and modify as you go. Over the years. Now, I would encourage you, if you've already gotten your wills or trust done, if you had them done before, when you were early married and your kids were, crawling around on the floor, it's probably time to get it reviewed and updated. If you've never had one done, then it's time for you to go find a good attorney. Now, I know there's some in our HCC, and you can ask them, or you may know of friends or families that have good attorneys that can write your wills and get or trust for you. So, okay, thank you. And if there's any questions, I will be happy to take them.
Karen,
Yes.
do you know much about transfer of and debt deed?
Transfer of
Debt
transfer of debt.
Debt deed.
For property. Yes, I
Yes.
understand. Yes, I understand. Texas has something like that. It's relatively recent. So you should I don't know the details of it, but I do know it exists. If you're in a simple situation, that may be a good way to do something. Be careful though. I had a very good family friend who was an attorney for many years. They were friends of my parents, and we grew up with Uncle Bill. And he advised my mother after she got widowed. She says, even though we were a very good family, 5 children and mom, and there was no way, in my opinion, that we're going to try to, cheat mom. He told her, you never transfer your property while you're living to your relatives or whoever while you're alive. Because what he had seen over the years was once the son or daughter and the in-laws got hold of it, they relegated mom to the basement and treated her badly. So now, and he'd seen it enough times. That's why he told my mother. And I remember him telling her, that. But thank God we were not that type of a family, but I know those exist. The transfer on death, that may be a little bit different. That doesn't transfer until the person dies. So you might want to check, go online. There's got to be some forms and things that you can fill out and get that taken care of. So it would transfer on death, but be very cautious if you transfer during life. Yes.
Wills and trusts, like if I draft myself, and then don't necessarily go through attorney. How to make it legal?
Okay, a very good question. She asked if she drafts her own will in her handwriting, how does she make it legal without going to an attorney? Actually, that's a holographic will. It is legal once you write it, and it is you and it is yours. It is a legal will, but the entire thing has to be written in your handwriting. You might want to date and sign it, even though that may, but the only caution I have for doing that is that you may accidentally or unknowingly leave out a lot of important other things that you may never have thought about. So you can start off with a holographic will, and then you take it to an attorney that you trust and have him or her make it strong. So yeah, that's a good start. I actually have a client who's just too busy to get her wills done. So she hand wrote the whole thing out. It's a very short one. And then she sent me a copy. No, she didn't. She called me and she said, okay, Karen, now if I die, okay, my will is under my blah, blah, blah. So I know in her house where it is. But I told her, you need to go see an attorney, take this little handwritten thing and have your attorney make it strong. Okay, now, when she was having all these health issues and she thought she might have some major deadly disease, you can be sure she actually went and got an attorney and got it all done. Yeah. Plus, she got the power of attorney for healthcare, and the living will, when to pull the plug. She got them all done. Yeah.
And can I draft not necessarily handwrite, but then draft using online whatever template, and then I then sign in front of
a notary or
notary.
yeah. The question is, How about if she drafts a will in her computer
Yeah.
and then signs it in front of a notary? Again, that is not in Texas. No, I don't know about other states. That is not a technically legit will. Some places might accept it. But if you're going to write a will, it has to be all in your entire handwriting. And can I have different color ink? Can I have different times you wrote the will where you add to it? Because you don't know if it's the same person or different people adding things for their benefit. So again, that's a good start if you fill out, kind of draft a will or whatever, and then you take it to the attorney to get it strong and valid in the state of Texas. If you move to another state, you should check their estate laws there because they may have it different from Texas. So you might want to check, or if you move to another country, you might want to check how their laws work for passing property to loved ones.
What if I have property in different states? Then I need to write.
Yes. If you have different properties outside of Texas, in Texas, you have to probate everything where that property is. So let's say you have property in, in a foreign country, and then you have property in Colorado, and then you have property in Texas. Well, in Texas, if you have a will that is probated, your executor or executrix has to probate it in Texas. If you have property in Colorado, another country, or California, your executor has to go to those probate courts in those states and probate that piece of property there. Did I repeat the question earlier?
Yes.
Yeah, okay. Okay, now that's a good question.
Karen,
Yes,
can I have a question?
sure.
This is Angela. Yeah, so if I have the will, trust, whatever is in Texas, but when I travel somewhere and pass away over there, where does
Yeah, that's a good question.
where to handle this thing?
Yeah, and so Angela's asking if she has property in Texas, but she's traveling, maybe going on a vacation or visiting loved ones or whatever, when she passes away someplace else. Well, your property is still in Texas, so it would be
Yeah.
probated in the state of Texas. Yeah.
Oh, okay.
And then they would have to fly your body back to Texas or have you buried wherever you prefer. Now, my mother wanted to be buried back in Hawaii next to my father. Okay, because he's buried in, and but I wanted her to live with me so I could take care of her. I was going to buy the condominium unit right next to mine. We're going to punch a hole in the wall so she can have the doorway into my unit. But after a few months of living together, you know how it is with mothers and daughters. We start. It was getting a little feisty, and so she said, besides, when I die, I want to be buried next to Daddy. And I said, well, don't worry, Mom. When you die, I'll just put your body on the plane. We'll fly you back and we'll bury you next to Daddy. She said, oh, how horrible. I said, Mom, you probably have flown with a lot of dead bodies on the plane and you just didn't know it. So.
Hi, Karen.
Yes.
This is David. I got a question. The trust, the will is pretty easy to understand. Just a piece of paper, my will, put it in there. The trust, the funny part I confuse is we have a trust. And recently somebody asked me, said, okay, do you have a tax ID for the trust? I said, it's just trust, no, it's empty trust, no money.
Yeah. Yes. Yes. So David's asking, he understands the will is pretty straightforward, but a trust, someone asked him, does he have a tax ID for the trust? Now, when I did my trust, because I got asked the same question, and my CPA said, oh, don't worry, Karen, your tax ID is your social security number, because everything flows through your trust as if it were you. So it did not have a separate tax ID for a revocable living trust. And that, I'm assuming that may be what you have. Now, if you have a different type of a trust, or like some kind of business related trust or something, that may have its own special EIN or tax ID or number that goes with that business entity kind of a thing. But this is where you would double check with your attorney, whoever wrote the trust. What I was told by my accountant and my attorney, because I have two attorneys and I have a CPA. Actually, I have two CPAs. I asked, and they also, oh, don't worry, Karen, because it's a revocable living trust, it flows through as if it just were you on your social security. And so that's how I do my tax returns. Everything goes with my social security number and I just pay my taxes through that because it's a living revocable trust.
Thank you.
Okay.
Karen, so two questions.
I'll take Holly's question first and I'll come back to whoever's online. Yeah.
So when you change your names on the account from Karen to Karen Ho Trust.
Yeah.
The tax you will still pay. So when they give you the tax, even though the accounting change, but the ID is the same. So that doesn't affect your.
Doesn't affect.
But when you go in to change your name, would that be the problem?
No, Holly's asking, when, if you have a trust and you have to change your name on the different accounts to say, instead of the Karen Ho bank account, checking account, whatever, it's going to say the Karen Ho living trust account at the bank or the credit union or wherever. So no, I did not have to change anything. It just took me about a year to contact all my credit union and my brokerage account and my car title and my condo title. And the attorney actually helped with my condo title, retitling in names of in the terms of the trust. But for the other accounts that I had, I would put Karen, I fill out their form from the bank or the credit union or whatever. And it just said the Karen S.I. Ho Living Revocable Trust dated March 30th, 1993, Revocable Living Trust. And then I just turned it in to them and they just, in their system, it should say, Karen Ho, blah, 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 trust. Now, when I get my checks and everything, it just says Karen Ho, but I know internally, because it's too long for them to type out. They don't have enough space in the fields of their computers to write that long thing. So in their system, they know what it is, but on my printed checks, it just says Karen Ho. Yeah. And what was the other question online?
Hi, Karen, it's Amy.
Hi.
Hi, for real estate, if it's titled joint tenant with rights of survivorship, will it pass without issues if the spouse is, one of the spouses non-US citizen?
That's where it gets, I'm glad you asked that. Amy's asking if you have real estate and it's joint tenant with right of survivorship, but one is a non-US citizen and one is a US citizen. The United States is very concerned about the non-US citizens scampering off with a whole bunch of assets. So they limit how much a non-US citizen can leave the country if their spouse has passed, the US citizen spouse has passed away. There's a dollar amount. Now, for real estate, I would suggest that may include the value of your real estate, but it depends. Oh, and it also depends on where the real estate is held. If it's held in Canada or is it held in Texas? So that makes a difference too. The deceased, the dead spouse is still going to have to do a final a final tax return. And they're going to also try to calculate if you have an estate tax. So it's, even though the property passes to the surviving spouse, there's still going to be, I believe, a final tax return that's going to list the value of everything. So this is again where I would suggest you see your attorney and or CPA and make sure you're getting it done right. The property might pass to you, but how it's handled in the final tax return and those other issues, you might want to make sure it's done properly. I hope I answered your question.
Thanks.
Sir, did you share your phone number before? Or is it
Martin's asking if I shared my cell phone number before. Yes, I did. It's 713-264-2475. Typically on a Sunday, I will not do any business. You should be all worshiping somewhere. Okay. However, if I know who's calling and I think it's important enough, I will answer. Okay. You can also text me. And if I know who's texting me, and if it's critical enough, I will respond. But if it's not that critical, I'm going to ignore it until Monday.
Eric, there's a question.
Oh,
What is the average cost for the will trust for Ensign?
Okay. What's the average cost for a will or a trust? Okay, I'll tell you what I paid for in 1993. And very simple situation. I did a revocable living trust. I did it and it had everything. It had all the bells and whistles. It was $1,250 for the whole package. And this was done by an attorney that was supposedly had a great reputation in Texas. Then for a will, I've also heard from clients that had done wills for their family. So there's a husband and wife and maybe 2 or 3 minor children. And I think the whole package for everything I think it was I think they did a trust. It was like under $3,000, if I recall correctly. Now for basic wills in Texas, I'll see them, and now, if you go to an attorney and they only say you want a will and they don't talk about power of attorney for healthcare, living living will or medical director and other things, I would say walk away. You want to make sure that any attorney you go to is going to not say only have a will or trust, but you're also going to address the powers of attorney, power of attorney for healthcare, and the living will when to pull the plug. So the whole package should be about what I've heard, $500, $750, maybe $1,000 total per person. So it depends on who you use. Okay.
Karen,
Windsor, what are you writing?
he's all right. Karen, this is
Yes.
Frank.
Yeah.
Questions. So at the very beginning, when you were showing all the distribution of all those estates, that is based on Texas law, right?
Texas law. Oh, you mean your estate, everything you own, if it passes by law, by trust, by will, or by contract, that one?
The one that you shows that if you have family, if you're married, and then how those.
That was for Texas. Thank you. That's Francis asking the graph I showed where if you pass away, it was for the state of Texas. That graph, that was kind of green boxes, and the spouse gets 1/3 and the children get 2/3 and all this. Yes, that was for the state of Texas. That's why you need to, if you move, you might want to double check how they pass their things in those states if you don't have a will. But better yet, Francis, get a will.
Yes, of course. But then does it also assume that these couples are married in Texas, or does it make any difference?
Doesn't matter.
Okay.
Yeah, because they live in Texas and they acquired properties in Texas and assets in Texas. If their stuff is in Texas, it probates into where their stuff is.
Okay. Thank you. Another question online.
Yeah.
Is the cost a one-time cost to pay the?
Oh, yeah. Is the cost, I guess, for wills or trusts, is it a one-time cost to pay the attorney? Yes. Okay. Now, I also suggest you, just have it reviewed. It's like getting a medical checkup every now and then, right? And you don't pay the doctor just once and go in forever for free. It would be every time you go in, it would be a relatively nominal cost. I'm probably guessing about a couple $100. I had some codicils or amendments to my trust. And at that time, I think I paid $125. And that was just to add the HIPAA waiver to my trust. And then I'm having some other stuff done right now. And so when that attorney did some things for me, it was a relatively nominal cost. It was like, I want to say not even $300.
Hey, Karen, there's a question. Can a spouse have his or living trust without the other spouse involved if he or she has a separate asset?
Okay, if you're talking separate, okay, the question is, if a spouse has a trust, can he or she have it separate from the other spouse? Is that what you're asking?
Right.
Okay, it depends. If you have separate property that you inherited from your side of the family, or just typically just all yours, 100%, or they gifted you from your side of the family, it had nothing to do with your spouse. But it's very important that you never commingle those assets with your spouse, because once you commingle the asset, or he or she pays, for the upkeep of it or whatever, and gets some access to it, it now becomes community property. So you would have to be very clear and keep a very good paper trail that this is separate property. And so when you have your wills or your trusts done, that it would specifically name that your separate property is to go to so-and-so and not to your spouse.
All right, thank you.
One more question.
Oh, okay.
Two more questions.
Does the husband and wife need to do the will separately if they have a united account? That's a good question. Yes, you all should have separate wills, powers of attorney or trust, powers of attorney for healthcare, and the living will separate from each other. In past, I have seen where they have what we call a joint will, but the problem is once one of you dies, the other one can't change anything in the surviving spouses. It's stuck, you're stuck. So it's best to have everything done separately. Yeah.
Sydney has one at the top. Does one
Oh.
require to pay tax for the estate getting from trust or will?
Oh, does one require to pay tax for the estate getting from the, I guess, the assets or the monies or the value from a trust or a will? You don't have an estate tax federally right now because you only get an estate tax if both the husband and or the wife together has more. I think it's they just increase it. If you have more than 12.06 million or $12.6 million per person in a husband and wife relationship, that would be what, 24 or 25.2 million between the two of you. Only when you go over that will you pay an estate death tax. As far as paying for taxes, that probably, you may be referring or thinking of, I hope I'm understanding this correctly, you're paying for the final tax return. Uncle Sam's going to get you coming and going. So, so when you die, you still got to pay tax one more time in the year that you die. So that's your final estate tax return. And only if you have a whole bunch of other assets that take you way over, you know, the $12.6 million per person, would you pay an estate tax. Now there's generation skipping tax, there's gift tax, there's all kinds of taxes. This is where you would work with a competent CPA and attorney to walk you through those things. If you're very wealthy, then you probably already have, hopefully you already have attorneys and CPAs working on your behalf and advisors. If not, I suggest you be contacting some soon.
Sydney means the receiver, so the receiver doesn't need to pay tax, I mean, right?
Oh.
When the receiver receives the estate.
When you inherit this stuff, no, you don't have to pay. When you, the question is, if the recipient of all those wonderful assets comes to the loved ones, do they pay taxes on receiving it? No, you don't. You just be very thankful and you very happy and you do the right things with the money that your loved one left for you. Now, one other thing is, I know life insurance proceeds from a death claim, even if it's a multi-million-dollar policy, those come out tax-free to the recipient. The only time you will pay tax on it is if the insurance company or you had kept it in some account and was earning some kind of interest or a profit, you would pay tax on the profit and the interest, but you would not pay tax on the life insurance death claim proceeds itself.
Question at the bottom, for money in the bank account.
Okay, for money in bank accounts or in a 401k, if you already set your beneficiary only for this part, the will or the trust is not necessary. Is that correct? You are absolutely correct. A contract, such as anything that names a beneficiary, like a 401k, a 401k, IRA, retirement plan, life insurance, annuity, variable annuity, fixed annuity, pension, all of those, where you name a beneficiary on it, those bypass a will. It trumps a will every time, and you do not have to go through probate on that.
So Karen, if you have a trust, you don't need to have a will, right?
That's
Or
why
you
I
need to
did
have
it.
both?
You are so correct. If you have a trust, you don't have to have a will. You absolutely, that's one of the reasons I did a trust, because I'm in Texas. My family is in California and Hawaii. I do not want to inconvenience them by forcing them to fly to Houston and figure out where's the tax probate, where's the probate court, and figure out where's the bank and where's all this and that and the other. So that's why I did a trust, so that they can dispose of all my assets and everything from either Hawaii or California. So you don't need a will. Now, a trust, internally, it already has, it should have with it the power of attorney for healthcare with the HIPAA waiver, and the living will when to pull the plug. So the trust will have all those 4 pieces. Anything else your attorney or CPA suggests, to have for your situation. A will have that, the will, that goes through probate, and then have the power of attorney for healthcare with the HIPAA waiver, and the living will when to pull the plug when you're terminal. So in a trust situation, so in my case, if I die, my revocable trust now becomes irrevocable. No one can make any changes, because as the grantor, I'm now dead. I can't make any changes to it. And my successor trustees can't make any changes to it either. So in essence, it almost becomes like a will, but there's no probate for it. So that's why in my case, I did a trust. Because before I had 3 wills when I was in Hawaii.
So what is the advantage of having the will then if the trust is better?
For those of what is the advantage of having a will if a trust is better? In Texas, probate is relatively simple, relatively not expensive, and relatively quick. Now, I don't know about now, because everything is that was in lockdown, and I understand the courts are so backlogged. It may be a different situation now, and I hear across the US or certain states, they're only working at, their court staff is only working at a fraction of capacity, because either the people, the workers are refusing to work, or they're ill, or they're dead. So had we been in a normal situation, and in the place like state of Texas, a will would be very doable in Texas and other states that have estate laws similar to Texas ones. But if you have a more complex situation, or you want privacy, you don't want everybody knowing what you got and who got what. Because I know when a lot of celebrities, when they pass away, that a lot of reporters are rushing down to the probate court. They pay a few dollars and they get a copy of your entire will, because they record that in the probate courts. You just pay a small fee. So even for privacy reasons, you can do a trust, or for convenience reasons, because you may have property all over, outside of Texas, or just for convenience, because you want your loved ones, even if you're all in Texas, you just want them to have an easier situation when you do pass, then a trust makes sense. This is where you would decide with your family and with your attorney or whoever, what makes the most sense for you and what you're comfortable with.
So I guess the trust is more expensive than the will?
Usually the trust will cost more, and it takes more time to retitle your accounts, your bank accounts, your credit union accounts, your brokerage accounts, to retitle it. Took me about a year, but I just kind of did it, whenever I got the form, then I fill it out, and then I submit it, and then I make sure that they recorded it in their systems, so it took about a year. And if you buy, that's the other thing. Some people will have a trust and they get it all funded properly, but then they forget and they buy this and that and the other, another piece of property, or they get another investment account somewhere, and they forget to retitle it in the name of the trust. And anything that was not retitled and renamed in the trust, those pieces are going to have to go through probate.
All right.
Yeah.
So we have to keep track of what we have.
Yeah,
Keep on updating.
yeah, it keeps, and that's why it's good to review and then let your loved ones that you trust know, so they're not blindsided.
If I didn't keep track of what I have, sometimes retirement, you move from one company, one company to another, about to, transfer, consolidate. You still, what is the recommended resource to go,
Oh, okay. The question was if a person has left employment and has maybe some retirement account and didn't transfer the account and what can they do? That's an easy fix. I think we mentioned that in the last session. And I do have a number of clients, they've got like 2 or 3 other accounts because they've changed jobs, over time. And a little here, a little there, but it's all of this paperwork. They say, oh, forget it. Just want to consolidate everything and control it. So I said, that's an easy fix. And plus the fact that I'm assuming you have a beneficiary designation, it doesn't go through probate. It goes directly to whoever you named as your beneficiary. They just need to make a claim on it. But in terms of consolidating them and making your life easier for you, and then eventually for your loved ones, you can do rollover IRAs, or you can do a rollover to your new employer's retirement plan if they have one, or you can convert it to a Roth, pay the taxes, and open a Roth IRA account. You can roll it over to a traditional IRA, making it tax neutral. You don't pay any taxes at that time of the transfer over, or you can just spend it all and pay your taxes.
Okay, there's one question.
Uh,
I see many, that one, the bottom.
I see many write your own will online software out there. Are these legal? Now, on the online, it's basically worldwide. So certain states will allow that. State of Texas is not technically legit. You can, as I said, those are a great start. You can film out. And then I would suggest that you take it to a competent attorney to make it strong and proper for the state of Texas. I do know in the state of Texas, when you have the fill in the blank ones, the probate judge will toss it out. They'll say, oh, too bad. This person has now died without a will. And then you go through the intestate process where you saw that graph with all those green boxes, and it passes. So, yeah, because you have to remember when anything is online, they're trying to make it very generic and apply to all 50 states and territories. So they're not going to spend the time to write one for every single state. Do the inheritance need to pay tax on the Roth IRA? Actually, since the Roth has already been taxed, you shouldn't be taxed again.
Should not.
Yeah, shouldn't be taxed. So, yeah, so when I left Baylor, I moved my 403B out and I said, go ahead, tax me, turn it into a Roth. And then I put it into a annuity pension. I made my own and I made it where I get lifetime income. So I'm going to get lifetime free income. And even if I go through all my money and they're still paying me, all of it's tax free is what I understand. Okay. So yeah, the Roth, but there's a caveat to the Roth IRA because the government wants the money circulating in the economy. So they're going to ask you the Roth IRA non-spouse beneficiary that I think you have to start moving the money out by I think it's 5 years. Yeah, you have to. They want the money in circulation. All right. So it's a little after 3. If there are any other questions, you can email me or text me or call me. I'm happy to try and answer. If I don't know, I'll try and find out for you. And I'm very thankful that you spent the time to learn a little bit more. But more importantly, I would really encourage you, if you do not have a valid will or trust done in the state of Texas with the other documents that we discussed, I would really encourage you to go see a good attorney and get those done. Thank you.
Thank you. So now that
Hi, Carrie.
Yes,
Carrie,
yes.
Do you have any attorney recommended?
I do have a list of attorneys that are all over the state of Texas, up north, and a couple here down this area that I will email. If you will email me, I'll send you the list.
Okay.
But you also want to have very good chemistry with whoever you work with, even though a lot of times you only work with him or her maybe once or twice, there's not that strong a relationship, but you still want someone you just feel really good chemistry and you trust. So even if the ones that I refer, you just don't feel, that one's kind of cold or whatever, you just don't have good vibes, then ask around, who do you use and how do you like him or her, and just go from there.
Okay, great. Thank you. Thank you.
Where can I-
Good job.
Oh,
Just in the email.
yeah, there's my work email. Where's, how can people contact? My work email is listed somewhere in the information on this seminar, as well as I've given my cell phone where you can text or leave me a message or call me, but I won't answer you on Sunday most likely.